Welcome back to AustLaw Simplified. Bailment occurs when goods are delivered by a bailor to a bailee, on the understanding that once the purpose is fulfilled, the goods will be returned or dealt with as instructed. The High Court in Bros versus Petersham Transport highlighted the importance of possession and control in determining whether a bailment exists. Bailment is about possession, not ownership. The bailor retains ownership, but possession and control pass to the bailee. It may arise from a contract or from circumstances without one. Even a finder of goods becomes a bailee if they voluntarily take possession. The classic classification comes from Coggs versus Bernard. Bailments can be gratuitous or for reward. Examples include leaving jewelry with a bank for safekeeping without charge, or leaving a car at a garage for paid repair. The distinction matters because the standard of care differs. A bailee for reward owes a duty of reasonable care. If goods are lost or damaged, the bailee must prove it wasn't due to their negligence. In National Trust versus Wong Aviation, the bailee escaped liability as loss could have occurred without negligence. In Jacob versus Lindors, the bailee failed to prove due care and was liable hence. A bailee is not an insurer of goods, but they are liable if employees or agents act negligently or dishonestly. In Morris versus C.W. Martin, a cleaning company was liable when an employee stole a customer's fur. If a bailee entrusts goods to an employee, they are responsible for the employee's actions. The bailor also has duties. They must warn the bailee of known dangers. In Pivovaroff versus Chernabaeff, a bailor was not liable because he had warned of the danger. In Derbyshire Building versus Becker, a defective power saw was supplied, breaching the duty to provide goods reasonably fit for purpose. Sub-bailments occur when the bailee passes goods to a third party. If the owner consents expressly or impliedly, they are bound by the sub-bailment terms, as in Pioneer Container. Additionally, the ACL guarantees services will be carried out with due care and skill and be fit for purpose. These guarantees cannot be excluded. A key distinction is whether possession passes. In Greenwood versus Waverley, renting a locker was a license, not bailment. In Ashby versus Tolhurst, leaving a car in a car park was held to be a license. But in Sydney City Council versus West, where a ticket was required to reclaim the car, bailment was found. Bailment can terminate in several ways: expiry, agreement, destruction, or wrongful act. Both bailor and bailees can sue if goods are damaged. A bailee can even sue a third party who negligently damages goods while in their possession. That's an overview of the bailment. Thank you for watching. See you in the next lesson.